name is Bonaventure. Welcome to our commercial class. Today, we are going to look at a topic known as partnership. Partnership is a relationship that subsists or exists between two or more people engaged in a business with a view of making profit. So, we are going to look at the relations of partners to persons dealing with them by looking at the contents of a partnership deed. We are also going to look at the relationship of partners to one another. Thereafter, we will look at the liabilities of minor partners and also the duties of an existing partner. Finally, we are going also to look at the solution of partnership, the reasons why a partnership has to be solved. We are also going to look at that. So to begin with, I have told you that a partnership is a relationship that subsists between two or more people carrying on a business with a view to making a profit. So, before a partnership comes into existence, there are certain things that have to be there and that have to be agreed upon. One, there is a partnership agreement which the partners have to make. One of them is that the name of the partnership and its permanent address must be known, must be written in a partnership deed. Also, nature of the business that these people are going to carry out must also be named. Also, the capital contribution of partners must also be stated in a partnership deed. Also, the interest on capital, if the partners will be earning interest on their capital, must also be stated in a partnership deed. Also, if the partners would be allowed to be drawing money from their business, it must also be stated in a partnership deed. Also, if such drawings will be earning some interest to the business, to the partnership, must also be stated. Also, the method of sharing the profit earned from the partnership must also be stated. And if there will be any salary, if one of them will be earning a salary, or if both of them, or if all of them will be earning a salary, if they are running the business together, then it must also be stated in a partnership deed. Two, there must exist some relationship between the partners, between these two people or more people carrying on a business or partnership together. The relationship that will exist between them must be understood by the partners. Otherwise, the running of the partnership will be a problem. If there is no proper relationship, there is no proper coordination, things will not be very easy for them to carry on their business, their partnership business. Therefore, if the partnership has to be run smoothly, each partner in a business has the implied authority to act in the name of the partnership, and such acts are binding on other partners. For example, a partner acting on behalf of the partnership, whatever he does, his acts will be binding to other partners. It is not like in a company, no. A partnership has no legal entity of its own. Therefore, any act that a partner does will be binding to other partners. Therefore, for example, when selling goods or when selling goods and services on behalf of the partnership, if he incurs a debt, other partners will also be liable for that debt because it's binding on them. He may accept also debts owed to the partnership. Those who are borrowing from who are drawing goods on credit from the partnership, if they pay debts, one of them collects the debt, even if it does not remit to the business, but in case such a thing happens, then it's binding. They cannot come up and say, no, you should not have taken. No. It is, if they serve a loss, they will serve all of them. So, a partner, each partner has a right to run the partnership and has a right to receive the money on behalf of of his fellow partners. And he also has a right to give out money on behalf of other partners. For example, to buy goods on behalf of other partners. He has that right. So, in a partnership, all partners are liable to whatever happens in the partnership. So long as what happens is, so long as they have, one of them has acted on their behalf and maybe he has incurred a liability. That liability will have to be settled by all the partners, except in cases where there is a minor partner. Where there is a minor partner in a business, a minor partner is a person who has not attained the maturity age, is below 18 years. If there is such a partner, and whatever liabilities that are brought about by these other partners, he or she would not be personally liable to such liabilities if he's a minor. His property cannot be attached for the firm's debts. No. His property in the partnership cannot be attached for the firm's debt. His share in the firm is liable for his share in the farm is liable for the farm's obligations. If he does not sever his connection with the farm upon attaining maturity age, he will be personally liable for the farms and debts since the date of his admission. For example, this minor, if he attains the maturity age of 18 years and he does not sever a relationship between these other partners, then he will be liable to all debts that happened during his admission as a minor. He will be obliged also to meet the cost of those debts. But once he attains the majority age and says, no, I'm no longer going to be in this partnership, there's nothing you can do about him. He will go scot-free. He will not pay any debt. And also, when we look at the duties of existing partners, if there is a partner and that partner is in charge of the partnership, he must render accounts to his fellow partners how he has been operating the partnership. He must give them the true account of how he has been running the partnership. He has to give them the true account on how he has been operating the partnership. He must allow his fellow partners to inspect the books of accounts in which he had been recording the transactions of the partnership business. Whatever he had been transacting on behalf of his fellow partners and recorded in a partnership book, he must allow his fellow partners to come up and inspect such a books to find out if those transactions that their fellow partners did were recorded correctly or not correctly. He must not be making secret profits without the knowledge of his fellow partners. Because if he does so, it would mean that he has another business within a partnership which is competing with the main partnership. And that one can lead even to the dissolution of the partnership. Because if one of the partners has gone rogue and is doing his own things, the only option that is there is for other partners to come up and dissolve the partnership. They may come up and dissolve the partnership. Therefore, a partner is supposed to act in good faith. Is supposed to act in good faith. Because when a partner has become rogue, then it would lead to the dissolution. Such acts would lead to the dissolution of the partnership. And I'm going to tell you the facts that may lead to the dissolution of partnerships, of a partnership. A partnership may be dissolved by a court order. A court order may dissolve a partnership. For example, if one of the members has become insane, where insanity exists among members of the partnership. If one of them becomes insane, then that one person who is insane will make the partnership dissolve, because you cannot run a business when one of you is insane. That would mean others might take advantage of him to sign documents which even he doesn't understand. And in that case, the other partner will be disadvantaged. Therefore, in that process, the law says that if one of the partners becomes insane, that partner will cause the partnership to dissolve. And also, if a partner is permanently incapacitated, for example, he becomes blind, he can't follow up well, whatever goes on in the partnership, that can also lead to the dissolution of the partnership. Also, in case of misconduct, if a partner is misbehaving, he does not listen to his fellow partners, he is not at par with the others. So what will happen is the other partners would consider dissolving the partnership so as to get rid of him, because there's no way you can get rid of him other than dissolving the partnership. Also, the partnership may, you see, a court order also may order a partnership to be dissolved if there is continuous, if the partnership goes on reporting losses year after year, then there is no need for such a partnership to exist. So a court may issue an order to dissolve such a partnership, which is just making losses. It does not make any profit. Also, if partners are not in good terms, if there is bad blood between the partners, they don't trust each other, a court also may issue an order to have such a partnership dissolved. Also, a partnership may also be dissolved without a court order. For example, partners may just come up and agree that let us dissolve this partnership, and then they dissolve mutually. They can dissolve the partnership that way by agreement. They just agree to dissolve the partnership, and they will do it. Two, if all the partners are declared to be insolvent, it means they cannot meet their obligations. Then that partnership can be dissolved. Also, if some event comes up which makes the partnership difficult to run, then it can be dissolved. It can also be dissolved. A partnership can also, the dissolution can also be done by a notice. If any partner, even if they are in good terms, but if any partner comes up and says he wants to withdraw from the partnership, and he gives a notice as required by the partnership deed, then the partnership will have to dissolve. Also, the partnership may dissolve on the happening of certain contingencies. For example, if the partnership period of existence has expired, then the partnership will have to dissolve, because they may agree that when they are forming a partnership, they may agree, the partners may agree that after 5 years we will wind up the partnership. And if the 5 years expires, then such a partnership stands dissolved. The partnership stands dissolved. Also, on the death of a partner, if by the will of God, one of the partners dies, when such a partner passes on, what follows would be for the partners to come up, agree, and dissolve the partnership. So the partnership can be dissolved by a court order, can also be dissolved without a court order, can also be dissolved by a member giving a notice, can also be dissolved by certain happening that makes the partnership impossible to be run. The partnership will also dissolve. So my good students, do further research to what I've taught you. Until we meet again, goodbye for now.